Hello, this is Attorney Brown Pendergraft with the Pendergraft firm, and the topic for today's video is when does a guest or occupant become a tenant in Maryland? And again, my name is Brown Pendergraft, and I'm an attorney that is licensed to practice law in both Maryland and in DC. But first, I have to give a quick disclaimer. This is legal information. This is not legal advice. So for legal advice, you can contact an attorney that is licensed to practice law in your jurisdiction. Alrighty, so here is the order of the presentation. So part one, I'm going to be redefining the question as a legal question. The legal question is, when is a landlord-tenant relationship established? And part number two, the short answer to that question is when a lease is signed or when rent is paid. That is when a tenancy is established. One's an oral tenancy, the other would be a written tenancy. And part three, what is rent, and can rent be something other than money? And I think the answer to that is probably yes. Part four is limitations on non-tenant or house agreements. So for example, you may move, so someone may be staying with you and they may have a sort of a house guest agreement instead of a landlord-tenant agreement. And I'm going to explain the limitations on that because sometimes people may accidentally inadvertently create a tenancy. Part five is possible exceptions to the rule that I talked about earlier, when rent is paid or when money is exchanged. That's probably a better way to put it, because I think that particularly when it comes to Airbnb guests, just because they pay money for a place to stay doesn't mean that they become a tenant. All right, part number six, what about family members that have lived at a place for years? I'm going to explain, I guess, the arguments as to why they think they have established a tenancy and why I think in most cases they haven't. Part number seven is a quick side note on adverse possession, because sometimes people will claim that they have adversely possessed the property. So I'm going to go through it briefly. So I have an entire video planned on adverse possession that I'm going to be doing. So I'm going to give like a quick brief overview on adverse possession and in this video, but the more extensive video is coming soon. Part eight, what if I'm still not sure if an occupant is a guest or a squatter? What to do then? And part number nine is, what if the occupant creates a fake lease agreement? What do I do in that case? All right. So if you've been watching this far and you're on YouTube, please like and subscribe so I can keep bringing you guys more fire like this. All right, and I also have an article version of this. So you don't want to sit here and hear me talk and stammer over my words and mumble and not be good at giving presentations. You can go visit my website at www.tpf.legal. You can watch the article version. Yeah, because I'm doing this raw. This is unscripted, so I just kind of go. I think my written version may be better. But all right, so part one, redefining the question as a legal question. And that legal question is, when is a landlord-tenant relationship established in Maryland? So the layman question is, when does a guest or occupant become a tenant in Maryland? And asking a question like that is good for search engine optimization, so you guys can find all my videos when people type that in. But for when it comes to, I guess, legal analysis and legal issues, it's much better to define it as a legal question, because that is how we win legal arguments, and that is how we sway judges. So the legal question that the judge will be pondering if they're hearing your case, that would be, how is a landlord-tenant relationship established in Maryland? That is the question. Or when is a landlord-tenant relationship established in Maryland? So that is a question that we need to answer. And the short answer to that question is when rent is paid or when a lease is signed. So now we're at point number two. So why is the problem? I have no idea why it's the problem up there. But yeah, so that's a weird header. I'm going to have to change that. So a written tenancy is established when a lease is signed. An oral tenancy is established when rent is paid. So I think the first one kind of goes without saying, that a tenancy is established when a lease is signed, because the parties definitely intended for a lease to be created in that situation. On the other hand, there are many landlords that unknowingly create that unknowingly establish tenancies. So they'll allow someone to stay with them as long as they're paying, let's say, rent every month, and they don't necessarily mean for that person to be a tenant. It's just they're not necessarily a professional landlord. Maybe they're just helping out a friend or something like that. But in that case, they have established they may very well have established an oral tenancy, and that person may now be owed, I guess, a landlord services, and you may not have intended to put yourself in that position. So that is why, once people start paying rent, you have to understand that that's creating an oral tenancy. And then my third point here that I have is that a gift is not rent, but it may very well be construed as rent. So someone may be staying with you and they may say, you know what, I'm going to, because you're allowing me to stay here, who knows, I may gift you with some money that you didn't even ask for, but you're such a good friend. I'm going to, you're looking out for me, so I'm just going to look out for you as like a gift or something. Now, that may very well not be rent in that case because it was a gift. But that said, a gift could very well be construed as rent. So you need to be very careful, even when accepting gifts, if someone's going to be staying at your place. All righty, point number 3. Can rent be something other than money? Alrighty, so money is a form of consideration. So consideration is a legal term that means X in exchange for Y, or value in exchange for a service. In this case, I guess housing services. So in the case of rent money, the consideration is or the X in exchange for a place to live. It's a rent money, right? So the X is rent money, but the parties are free to make the X something other than money, so long as it's legal. You know what I mean? So you can't just, for example, you can't exchange sexual services for a place to live, right? Because that would be considered a legal consideration, right? So I can't just be like, all right, you know what I mean? She wants a extracurricular services from attorney fees. Like, no, I can't do that for a place to live. However, I can provide legal services as a form of consideration for a place to live. So that would be rent legal services. So I can give rent legal services. If you're a barber, you can bargain that you're going to be giving a weekly haircuts in exchange for legal services. So that is something that you can not legal services, in exchange for a place to live, perhaps a weekly tenancy. See, this is what I mean. This is why you guys need to check out the written version, because my mind is in like 4 places at once, as you can tell. So the problem with consideration being something other than rent money is that it becomes very difficult to prove if it is not particularly if it's not in writing. Particularly if it's not in writing, it can kind of difficult to prove that I'm exchanging legal services for a place to live. So, if I'm doing that, then it should probably be in writing. On the other hand, rent, you know what I mean? I think that's a lot easier to prove because you can create like a paper trail. You can have receipts and all that good stuff, but it's kind of difficult with let's say legal services or something like that. So the last point that I have on this slide is, what about paying bills? Because, some people may agree that, let's say, paying bills is a form of consideration that they should be allowed to say. And sure, if the parties agree to that, then I think it's valid. On the other hand, I have had a case where I represented the owner. We'll call them the owner. They're actually the master tenant, believe it or not, but we'll call them the owner just for the sake of simplicity. So the owner, they leased to their tenant, well, their subtenant, but to their tenant. And, they did not lease to their tenant. Scratch that. They did not lease to their tenant. They did not allow them. They just let them kind of stay there, right? But then this person took it upon themselves to start paying bills to make it look like they stayed there. So when we went to court, she tried to argue that, hey, you know what I mean? I am a tenant. I am paying bills. You know what I mean? Therefore, I am this person's subtenant. But, we made the argument that they did that without our permission. And, we won because, we won in that case. But again, so be careful when it comes to, paying bills and stuff like that. Alrighty. So, this is the wrong slide I have no idea how the slide is here. Skip this slide. All right. Part number 4, limitations on house guests or non-tenant agreements. So what is a house agreement? A house agreement is a written agreement that says that the occupant is not a tenant. So this could possibly be good evidence that the relationship is not a tenancy. However, just because a contract says that there is no tenancy does not mean that there is a tenancy. So a house guest agreement would be like, say if I have, I don't know, a friend coming to stay over the weekend, and I'm just like, I'm very paranoid. So I'm just like, you know what, friend, I'm going to make you sign this house guest agreement that says that you're just staying for the weekend and that you're not a tenant, and you're not paying anything. You know what I mean? You're just a house guest. You have to leave after the end of 48 hours or whatever it may be. So that would be like a house guest agreement. So, and again, but as I was saying, just because a contract says that there is no tenancy does not mean that there is not a tenancy. So if a person is paying rent, so if a person has a house, one of those house guest agreements, and they're paying rent every month, then it's probably a tenancy. So in other words, parties can sign a contract saying that the sky is green, but that doesn't change the fact that the sky is not green. The sky is blue. That might be a bad example because some places the sky might actually be green depending on how you look at it. But all right, see, just check out the article version. I am not on it today. So what was it saying? So in other words, that if it looks like a tenancy, it probably is a tenancy. You know what I mean? And a lot of times that it's going to bring to my last point on the slide. There's a lot of times where it could be a house agreement could be perceived as a way for an owner to just kind of skirt around providing landlord services. So it's like, all right, cool. So we're just going to have this house agreement that lasts for a year and you're bound to it for a year. You have to pay me rent every single month and I don't have to provide housing services because you're a tenant. You're not a house guest. No, that's bull. All right. That person is a tenant at that point. So yeah, be careful of that. All righty. Point number 5. Possible exception for short-term rentals, aka people who pay money for a place to live. So, and just because a Airbnb guest or short-term rental guest, just because they are paying rent for a place, or I'm going to call it rent, but just because they're paying money in exchange for a place to stay for a temporary amount of time, I do not believe that they are tenants. That said, I'm going to, explain my reasons why, but I could be wrong. That's my first point on this slide. I could be wrong. The law kind of needs to update on this. So, I think the law needs to be updated to kind of clearly define the relationship between a owner and a short-term guest. So hopefully those laws come soon. I know Airbnb has been around for a while now, but the law updates very slowly. So my argument is that using a short-term rental is kind of like using a hotel, and hotels are essentially short-term rentals is what they are. So hotel guests are, and they're not tenants. So when you go to stay at a hotel, you're not establish a landlord-tenant relationship with the hotel. The legal relationship between you and the hotel is an innkeeper-guest relationship. So they are the innkeeper, you are the guest, and they have an entirely different set of rights and responsibilities than a landlord-tenant relationship. However, they are there. I'm not saying that one has less or more protections. They're just different relationships. And my thoughts are that for people that are short-term rental owners, is that that they have an innkeeper-guest relationship with their occupants. Now, of course, the counter argument here is that, which they will argue, and perhaps their attorneys will argue, is that paying for a place to stay establishes a tenancy. But again, so you have to be prepared for that counter argument, I guess. All righty. Moving on. Point number 6. What about family members that have stayed for years? So I've often had cases where I needed to help someone evict a family member because they will, a lot of times a family member will stay at a place, perhaps their grandmother's house or maybe even their parents' house or something like that, and they will claim that they have a right to live there because they have lived there for so long. And yeah, there are a few common arguments that they have, and for the most part, I can, I guess, debunk most, if not all of them. So, one of the arguments, or one of the things that they think, is that I have lived there for so long, I am now a tenant. In which case, the answer to that is probably, oh, it may be. If they were paying rent, then yeah, but chances are, or in many cases, they are not paying rent. So that's something to consider. Something to consider: is this person paying rent or not? So point number 2: I am an heir, and the personal representative has no right to evict me from mom or grandma's house. And the answer to that is they most likely, well, and I would say maybe we need to look at the will. That said, and I've had many cases where just because someone is an heir and they're living at the house doesn't necessarily mean they were not illegally entitled to stay at the house. The personal representative still had a responsibility to settle the estate, and in this case, it meant that they needed to sell the home, and they couldn't do that with that person living in there. So I had to file in order to evict them, and they were an heir, so they were entitled to their percentage or their portion of the proceeds from the sale of the home. But they weren't entitled to stay in the home. So that's how that went. So point number 3: I've lived there for so long, I now have squatters' rights. No, you don't. So, or maybe they do, in a sense that if they've lived there, so now they so now you have to go to court in order to evict them and file a wrongful detainer action, and that is how you evict squatters, with wrongful detainer actions. So I guess they're right. Alrighty, and point number 4: I've lived there for so long, I now have an ownership interest through adverse possession. I've adversely possessed my grandmother's home, and that brings me to my next point. Point number 7. A quick side note on adverse possession. All right, so this is going to be a very minimal overview of adverse possession because I have a full video on adverse possession coming. It'll probably be my next video after this one, honestly. So, in order for adverse possession or for possession to be adverse, it must be. All right, so these are all legal terms that, again, I'm not even going to bother defining most of the. I'm definitely going to say that for my next video. So it must be actual, open, notorious, exclusive, hostile, under claim of title of ownership, and continuous or uninterrupted for a statutory period of 20 years. So let's say, I don't know, grandma's son has been living there for his entire adult life, and he's lived there for 30 years. And he thinks, like, I've been here for 30 years, I'm the owner now. So in the case of a family member or staying at the home, let's keep up with that same example that I just used. So in the example that I just used, the family member staying at the house, it's most likely not hostile. So in order for it to be hostile, it essentially needs to be against the wishes of the owner. But in this case, it's chances are grandma or maybe even mom they're enabling you to stay there. It would also need to be exclusive, right? So that element needs to be met, and it's probably not exclusive possession because if it's probably the family home. You know what I mean? Grandma's probably there, mom's probably there. There might be 4 or 5 generations at grandma's house. So yeah, in that case, just because someone's lived there for very long doesn't necessarily mean that they have adversely possessed the property. And in fact, in many cases, I would dare say in most cases, people have not succeeded in adverse possession. But I said, I got my adverse possession video coming soon. All right, so point number 8. That's why I have that 8 ball there. So what if I am not sure if the occupant is a guest or a squatter? So what to do, right? So there could be a situation for, it can be difficult to tell sometimes. So there could be a situation where an occupant who is staying at the property, say you bought a property and there's an occupant staying there, and they claim to have leased from the former owner or something. So maybe you bought a property that was foreclosed on. They foreclosed on the former owner. The former owner had a tenant in there. There's there's an occupant in there. We don't know if that's their tenant or not. But there's an occupant in there, and this occupant is claiming to have leased the property from the former owner. Now that may or it may not be true. It may or may not be true. You know what I mean? In that case, where I'm unsure, I'll file both holdover action and a wrongful detainer action at the same time, just so I can, just so they can both be heard. I'll get the same court date. And I'll be able to tell the court, like, one of these is one of these is right, and the court will agree. One of those is right. So essentially, I'll take the steps to get them out of there with both. Treat them as a non-tenant and as a tenant. All right. I think this is my last point, number 9. We are in here. I've stumbled my way all the way through to greatness. All right, it's the point number 9. So what if I didn't even say what the point was. So point number 9, what if the occupant creates a fake lease? Point number 9. So, so what do you do if someone has a fake lease? So you have to take them to court. So you have to be prepared to argue that the lease is fake. And you should also consider filing a lawsuit against them for fraud, because that is fraud. And you have suffered a lot of harm due to their fraud, most likely. So you can file a lawsuit to attempt to recover from that. And that is it. We are now done. Thank you for watching. So if you have any questions that you would like to be considered for my Ask Attorney P series, you can visit my website at tpf.legal/ask. And that'll bring up a link where you can post a question. And thanks for watching. And again, my name is Brian Pendergraft with the Pendergraft Firm website, tpf.legal. Email info@tpf.legal, on that good stuff. Hit me up. Thanks for watching. Like and subscribe. I'm out.